We welcome you all for today's class on forensic psychiatry. Today we have with us Dr. Guru S. Govt, who is Assistant Professor of Psychiatry in currently working in forensic psychiatry. Welcome you, Dr. Guru.
Thank you.
Today we'll be taking you through some of the concepts in Mental Health Care Act. So over to you, Dr. Guru.
Welcome you all for today's presentation on Mental Health Care Act, specifically focusing on advanced directives, nominated representative, and also on right to person with mental illness. As you know that our Mental Health Care Act of 2017, which is enacted on April 7th of 2017 on World Health Day, and totally around 16 chapter, and also it contain around 126 clause. So what is the need for a new Mental Health Care Act of 2017? What is the need being that like lot of Supreme Court litigations happened, public interest litigation happened with respect to right issues, with respect to the advanced directive issues, and also National Human Rights Commission visited and highlighted the lot of gross deficiency of services with respect to installationist care of person with mental illness in mental health asylums and existing mental health hospitals. And also National Mental Health Policy, it also talks about providing a care to person with mental illness with the least restrictive care, and also focusing on more of adequate community-based care. So looking at all these aspects, which made them think to have either amendment in existing Mental Health Act of 1987 or come up with a new law. And also, if you look at in 1965 to 2006, India signed as a signatory body for many conventions. This convention on elimination of all form of racial discrimination, International Convention for Civil and Political Rights, International Convention on Social, Economic and Cultural Rights, and also in UNCRPD, which talks about conventions for right to person with disability. In this regards, so either we have to come up with a new law, or else we have to amend existing law to harmonize with the conventions and also PAL and also National Mental Health Policy. To focus on morely on rights of person with mental illness and also promote their access to mental health care in India. In this regards, Ministry took professional opinion from different stakeholders, right from NGOs, psychiatrists, psychologists, social worker, nurses, and caregivers, and also from human rights activists and legal academics, and also professionals. With that, so what decided is that a lot of amendment is required in this act. They want to come up with a new Mental Health Care Act. So in April 2017, they come up with a new law. It's called Mental Health Care Act. So in specifically focusing on Mental Health Care Act with respect to advanced directives, Mental Health Care Act Chapter 3 talks about advanced directive in details. In this regard, advanced are the documents made by persons with a decisional capacity stating about its treatment preference in case of future lack of capacity. So does India fastest country to implement these things, or any other countries are followed? If you look at in the last 3 to 4 decades, like advanced directive concept is going on many Western and high-income countries. So especially initially started with more of an end-to-life care options by Louis Cantor. Later, it was introduced in psychiatric care. They have used different terminologies like joint crisis card, joint crisis plan, and supported decision-making card, or cognitive advanced directive, and many more. So in that wise, so what does advanced directives in mental health care talks about? It talks about that the way person wish to be cared for and treated for a mental illness, and the way person wish not to be cared and treated for a mental illness, the individual in order of preference if you want to appoint as a nominated representative. These 3 things are explicitly documented in our Act. So these are things which talks in our Mental Health Care Act. So, who can make an advance directives? The law says that every person who is not a minor shall have a right to make advance directive in writing, specifying any or all of the following, irrespective of his past psychiatric illness or on treatment or whatever. So, when is this advance directive be invoked? When the person ceases to have a capacity to make mental health care or treatment related decision, that time AD will come into invoke. So remain effective until a person regain the capacity. So advanced directive will not come into picture in first 72 hours in emergency treatment. So our AD can be not be invoked. So it can give a treatment for the patients in during that context. How to make an advanced directives? So for making an advanced directive, there is a regulation made by a central authority. So we have to follow that regulation. Based on that, a person can make an advanced directives. So also talks about maintaining an online register about by the Mental Health Review Board about advanced directives. Can it be challenged? Yes. So if any person who can made advanced directives afterwards, either a mental health professional, relative or caregiver can challenge in a mental health review board regarding is to alter or. So what are the liabilities? So person who made an advance directives are nominated representative as duty to provide advance directive is to provide an advance directive doctor. It's not a liability on doctors if they're not given a copy of advance directives. It does not mean liability if any unforeseen consequences happen by following a valid advance directives. In case of child, legal guardian can make an advance directive behalf of child. So, what is nominated representative? In chapter 4 talks about nominated representative in Mental Health Care Act of 2017. Every person who is not a minor shall have a right to appoint an NR. NR cannot be a minor, at least is more than 18 years. NR has to give a consent in writing to discharge his duties and perform his function as an NR when patient capacity lost. How to make an appoint an NR? In writing on a plain paper with a person's signature or thumb impression is enough. The board can appoint or revoke or alter NR on the application made by person, relative, or a doctor. In case of child, legal guardian is a NR unless he is not fit to be NR or nor acting in the best interest of child. Who can be NR? Individual appointed as a NR by a person, or it may be a relative, it may be caregiver, or a suitable person appointed by board. In case a homeless person with mental illness, director of Department of Social Welfare or his designated representative can become NR. What are the duties of a nominated representatives? So considering the wish, life history, cultural background, values, and best interest of person with mental illness, the NR has to provide support to the persons in making treatment-related decision under Section 18 and 19. And also, NR can seek medical information of the patient on diagnosis and treatment with respect to care. NR has access to home-based rehabilitation services for the benefit of person with mental illness. NR can also involved in discharge planning procedure. NR can also apply to the mental health establishment for admission under Section 87, 89, or 90. Apply to the board on behalf of person with mental illness in discharge procedure with respect to Section 87, 89, and 90. NR can also apply board against the violation of human right in the establishment or settings. NR are right to withhold or give a permission for the research when patient lost the capacity. So most important aspect, right to person with mental illness. It's considered as the heart and soul of the Act. Mental Health Care Act is the first time in clearly article about what are the rights of person with mental illness in current Act. So we'll go into an advanced directive. So especially Central Mental Health Regulation come up with an advanced directive for mental illness form. It's called a CRA form, where it talks about that, like the person names, age, father's name, mother's name, and the patient address to be to be enclosed, and relevant document has to be attached. In the, as is mentioned in the Act, it talks about any wishes to be cared treated for under establishment, under doctor, whatever a person can write, and also what wishes is that does not want. If he has any specific allergy, side effect with the medication, he can also mention in the CRA form. And CRA continuation form talks about that, like you can choose any number of nominated representative and also give a order of preference. So once he chooses a nominated representative, he has to get a signature regarding consent to become an NR and with a date. It has to be signed by two witnesses regarding his, he made an advance directive on his own free will and decided in the presence of two witnesses. So what other regulation talks about that, like it should be written in a CRF form, and representative shall sign advance directive stating his willingness to act as a NR, and also two witnesses has to sign, and copy of the advance directive should be given to NR also. So after making a valid advance directive, he has to submit this form to a relevant or a jurisdiction board where they will look into these things, and this will not be charged for registration of advance directive. Within 14 days, it has to be made online, and person can make a new advance directives consecutively and not less than 3 months. So you can make an advance directive every 3 months or more than that period. And when you make a new advance directives, the old advance directive become null and void. And concerned persons or nominated persons shall may be possible to inform treating mental health professional about new advance directives. No person shall release any copy of advance directive information to unauthorized person or a media. A nominated representative person concerned with advance directive may withdraw his consent to the function as such at any time without giving any reason through written application addressed to the board and a notice of such withdrawal of such person. So regarding right to assess mental health care, every person with mental illness has a right to assess mental health care in a run or funded by a government institute, and the facility should be in affordable cost and good quality and good quantity. In case of the facilities are not there, the government should give a compensatory money for the patient who assess mental health care. And especially in terms of below poverty line and destitute patient can access mental health care free of cost. It also talks about that providing health services for inpatient, outpatient, rehabilitation, and emergency-based care. So it also says that every district should have a child and old age-based services. And it also talks about that every district should have a home-based, hospital-based, and community-based rehabilitation center, and to have community emergency-based services at community health center and upward taluk health center, district hospital, and also run a halfway home, sheltered home, and support accommodation. And also talks about that integrate mental health into general health in primary, secondary, and tertiary care. So it also talks about that to enlist the essential drug medication by a government at different settings. So district hospital, they expect to have an allopurinol, risperidone, olanzapine, propanazine injection, allopurinol injection for psychotic disorder. For any depressive disorder, acetylopam, fluoxetine, and imipramine should be available. For a bipolar disorder, lithium, carbamazepine, sodium valproate, olanzapine should be available. For generalized anxiety disorder and sleep disorder, availability of clonazepam, lorazepam, and also an zolpidem. For OCD, the capsule fluoxetine 20 mg should be available, they say. So in the respective taluk level and primary health center, similar medication are notified to make it available at settings. As a person with mental illness has a right to live in a community. He considers a part of community. So he has a right. So he can the government has a duty to create a community-based facilities in terms of a home-based rehabilitation or community-based rehabilitation, and also create an RP home, sheltered accommodation, and group homes. And all these settings should be in a more of least restrictive nature, so where patient can visit and can also plan for any community-based activities. So another important thing, it talks about that right to protection from cruel and inhuman and degrading treatment, where treatment for the person with mental illness in establishment in a safe and hygienic environment, and establishment has to ensure adequate sanitary condition. Establishment should have a leisure, recreation, education, and religious practices. Establishment also focus on privacy and of the persons with mental illness and clothing, and not to be forced to undertake any work in a mental health establishment. Um, to receive a appropriate remuneration for a work if they are undertaken in a mental health establishment some work. Adequate provisions for preparing for living in a community has to be looked in MHCs, and also provide a wholesome food, articles for a personalizing, and especially in particular with women personalizations. So saving of head days is compulsorily banned. To wear a own personal clothes should be prepared, and not to force for a wear a uniform in a establishment settings. And to be protected from all the form of physical, verbal, and emotional and sexual abuse. It also talks about right to equality and non-discrimination. So in that aspect, like equality to person with physical illness is in provision for all the healthcare. So to provide any healthcare equivalent to physical illness, it's obligation on the state to provide emergency facilities, emergency services for the person with mental illness, like ambulance and appropriate living conditions, and what we provided for a physical illness. And also insurance for those with mental illness. Insurers make provision for the medical insurance for the treatment of mental illness on the same basis as is available for treatment of physical illness. The patient has a right to seek for information, what is the reason for admission. If a patient can also go for a review of his admission procedure to the medical board, and also look for what treatment you want to choose, and it has to be explained in patient's own vernacular languages. Patient also has a right to confidentiality. In that aspect, the confidential information can be disclosed in exceptional condition when to a nominated representative when patient capacity ceases with respect to admission, treatment, and discharge plan procedures, and also other mental health professional or other health professional to enable them to provide a care and treatment for the person with mental illness. And in case of patient is self-injurious or he may harm somebody, in that context, medical professional or mental health professional can disclose the information to others. In case of medical emergencies, life-threatening condition, the confidentiality can be broken. In the interest of public safety and security, and in case of judicial proceeding, patient's confidential information can be breached. So, especially the patient's illness information or in patient photograph not to release to the media without the consent of the patients. The consent required to store the digital and electronic format of the data either in real or virtual spaces also. So patient has a right to access medical record, both outpatient and inpatient medical record, which is prescribed by Central Mental Authority. It's called a State Basic Medical Record for OP and IP patients. Mental health profession can withhold medical record in case of disclosure would result in more serious mental health harm to self or others. And the person with mental illness can apply to the board in case if mental health professional withhold medical information, and can be sorted at the mental health review board level. This application with that when patient can apply for his medical record. This is an outpatient medical record form where the mental health professional can issue these minimal details to patient when he asks for outpatient-based medical record. It includes name, his father name, his phone number, his address, and also his age and then gender, whether he has advanced directives or not, and date of visit and time of visit, and what is the complaint and duration with that he reported to mental health professional. What was a possible either provisional diagnosis, differential diagnosis, what they made, what treatment advice, and follow-up recommendation, and follow-up date. These are the bare minimal details what is required for mental health professional to keep it in medical record for each consultation, whether we provide treatment at establishment, in community, or camp. This is an inpatient medical record, basic medical record. In that, like along with patient details, the mental health professional has to keep mode of admission. Is admission is supported, or which section in under which he got admitted? What are the chief complaint with that he got admitted? And his identification marks, and summary of medical examination, summary of investigation. What is the course in the hospital? Type of discharge, condition at the discharge, treatment prescribed at the time of discharge, what are the follow-up recommendation, and when doctor is calling for the follow-up date. So in case of therapy records, so it's similar to an outpatient and inpatient medical record, where you have to collect in a patient bare minimum details. Along with that, duration of session, participants in the session, and type of therapy patient underwent, whether it's individual, couple, or a group, or what are the objectives of the sessions, and what are the key issues were discussed during the therapy session, and what are the therapy technique therapist used that point of time. If it is a supervised session, then supervisor signature also helpful to document, and the RCA registration number and relevant professional details. Patient also has a right to pre-legal aid, and it's a responsibility of doctor if patient need of any legal help to send across to any pre-legal aid services. And in case of right to person, person also has a right to personal contact and communications. So those who are admitted in the establishment can avail mobile telephone mail services of their own, or established can make provision of that. In a hospital norms, they can have some recommended time in a day where that time patient can use these services, or patient has a right to see somebody, right to refuse somebody in the during IP care setting. So patient has also a right to complain about deficiencies in the services in the establishment. Either in the first level, he has to complain to the in charge doctor of establishment. When that problem is not rectified, he can hike up this issue to mental health review board, and if it is not sorted out, then he can go for a state mental health authority. I acknowledge mental health care management system and Professor Suresh Badamath and Dr. Vijal and also Harun for his slides and material.
Thank you, Dr. Guru, for the lucid presentation. Now the session is open for discussion. If anybody has any questions, you can either unmute your mic and ask the questions, or put it in the chat. We'll take it up, or you can also raise your hand in the chat option. Then we'll unmute your mic, and then you probably can ask the question. Dr. Birwa, can you please unmute your mic and ask the question?
Am I audible, sir?
Yeah, Dr.
So what is the provision in the Act regarding surreptitious medications?
The Mental Health Act of 2017 is very silent about use or practice of a covert medication or surreptitious medications. So it does not talks about that.
Thank you, sir.
Dr. Praveen Naukare, can you please unmute your mic and ask the question?
Sir, I'm Dr. Praveen Naukare from state of Maharashtra. Sir, I would like to know in which state of India the new Mental Health Act has been implemented or has been in work.
Okay, you want to know about developments about Mental Health Care Act of 2017, right? So basically, yes. So many states per se, they have drafted their drafts on state mental health rules, okay, including Karnataka, Tamil Nadu, and Delhi, and many more states are there. So this has to be gazetted, then it to be enacted. So and also in central also, the central also come up with central mental health rules and regulations. So they have to now also they have a central mental authority which started functioning. So as of now, the center-wise, we have a CMHA which is functioning, and also they enacted central mental health rules and regulation. Now they also have to come up with a minimum standard of care related notification. What is the minimum basic standards? With that, they can run a mental health establishment. And with respect to state, as of now, my knowledge is concerned, all are in draft phase, especially state mental health draft rules.
And to add on to Dr. Guru's comment, as far as I know, most of the states have sent out advertisements for the members, seeking members for mental health review boards. So once these review boards have come up, the mostly central mental health authority is already there. So state mental health authority and in every district probably mental health review board would come up. As far as now, most of the advertisements have gone out and they're still awaiting for the responses. But it is also true, Dr. Praveen, that the central government has issued notification to all, at least central government institutes like NIMHANS, to start following Mental Health Care Act. Not only in admission and discharge procedures, but also keep Mental Health Care Act in mind when they are taking professionals, hiring professionals also. So we, I think about 3-4 months ago, we have received a notification on this matter. Dr. Amrit Pal Singh, can you please unmute your mic and ask the question?
Sir, I want to ask what will be the status of confidentiality when an insurance company asks for medical record of the patient?
Okay. So especially when a person, when he apply for an insurance, especially medical insurance for his illness related that, he will sign that his medical related information will be assessed by an insurance company when he seek for a compensation related to that. So in that context, you have to see that whether that disclosure, that signature has happened between the contract established between an insurance company and person who applying for the compensation under insurance. So after that, you can disclose the information. So better what we follow is that we'll give a medical record to a person who's seek for the insurance related benefits. So you will submit that record to an insurance company.
So what is generally practiced here is, as Dr. Guru was telling, that the person will request us either in usually in writing that they would require their medical records for insurance purposes, and then we would release the records of what probably would be required for insurance purpose. Not everything would be probably required. Not the whole file would be required by the insurance company. A summary of that would be required. So usually the summary is provided to the person who is seeking. So then this person it's up to them to contact the insurance company and hand over that document.
That's a way what practically we follow. But most of the time, when insurance companies, the contract established in the person and this thing, that time they have a disclosure that their information will be used in case of like when they ask for compensation or insurance claims and other things.
Dr. Birwa, you can unmute your mic and ask the question.
So what about proxy medications? Can they be given if a relative comes and asks for medications?
It's in a very what you call ethical questions where here proxy consultation and court medication can be given to the patients, but and with respect to law, it's very silent. But patient has a right to choose or right to refuse the medications. So in that context, whether if relative coming and asking for the prescription, whether in that context, whether you have a right to give prescription to them or not is really risky. But we usually institute, most of the centers they follow still giving prescription to them. But as a professional, you should be you have to take in a more of neutral stand related to that. Anything you want to add?
As far as the law, this law goes, there is nothing on proxy medication or covert medication is not to be given, but on proxy consultation there's nothing. But we should also remember that this, it's not only about this law. There is also ethical guidelines set out by Medical Council of India, which says that the covert medication and proxy consultation should not be given, including consultations without general physical examination, probably not in mental health setup, but in other setups, without a general physical examination, medicines can't be prescribed or medicines can't be changed, is the code of ethics from Medical Council of India. So usually when these kind of cases goes to the court of law, it's not only mental health care act, they'll also look at the MHCA rules and regulations, and because of which proxy consultation and covert medication is not advisable at this point of time. So, Dr. Sunaina, can you please unmute your mic and ask the question?
Good afternoon, sir. Sir, it is regarding the mental health review board. There are patient and their caregivers in making decisions. So my doubt is, as such, a psychiatrist's role is very less. So how far can we depend upon the review board? Because it is about in making patients' decisions.
See, the mental health review board in specifically, it's come. So only thing is like whenever conflicts arise between mental health establishment versus patient or caregiver, or a mental health professional versus patient caregiver, they can go to a mental health review board. So before that, like most of the decision happens at the care will happen at establishment with the patient, professional with the patient. So in the mental health review board, is a body consists of around 5 to 7 members. One psychiatrist will be there, one medical officer will be there, and one retired judge will be there, one person with mental illness will be there, one caregiver will be there. It's a constituted of 5 members. It's just not a either part of a medical community or in a legal community or in a just consist of only patient caregiver. It's in a constituted way all 5 of them. So in that context, it's a fair process. Like we have to view patient views, we have to look into professional views, we have to look into legal angle to that. In that, like Mental Health Act taken a very good stand, including all professionals and also care seekers, care providers in the board.
if I can add, we should also remember that not only Mental Health Review Board, even IRBs, Institute Review Boards or ethics committees in all the institutes should also contain people, general people, I mean, they're general public, people taken from general public. So why this needs to happen is that if they're only professionals, for example, there is always a chance of abusing the system. That we all know we would want to help the patient, but having said that, it would be the person who is taking treatment. He is a bigger stakeholder in this, as bigger a stakeholder as the psychiatrist who is treating them. So if we leave out the person, the larger stakeholder in this, then it is a disservice to the person. So in that way, what Mental Health Care Act has done is that, so it has included all the stakeholders, including psychiatrists, general medical person, judge, caregiver, person with mental illness. So everybody here has an equal footing in this. So it's not, see, as Dr. Guru was pointing out, now when it goes to a mental health review board, we should remember that it has already crossed the expertise of 2 or more psychiatrists. Now, a single psychiatrist, if they can't make a decision, now there is a provision that there are 2 psychiatrists who will come in and make decisions. And if that is also to be questioned, then it is beyond the purview of just psychiatrists. So it goes to a mental health review board where there are many more people who will pitch in and then help us take the decisions. One may ask that why would we need somebody else to make decisions for us? Because we should know that mental health is the only area in the whole of medicine and surgery that somebody's capacity is compromised, and somebody will have to make decisions for this person whose capacity is compromised. So because there is loss of capacity, there is always chance for abuse. So to prevent this abuse happening, these steps have been taken.
And also there's a lot of power given to a professional like a psychiatrist, a mental health professionals with respect to admitting the person with mental illness for a period of 30 days involuntarily. So except legal or judicial custody, so as a doctor you have a power to admit somebody against their will. In that concept, when you have a power, then also have some control over this power by a mental health review board, especially regulating not to abuse these powers what they given to professionals. Yeah, mental health review board consists of who are all. So mental health review board is a quasi-judicial body which consists of a retired or functioning district level judge and psychiatrist and also a medical officer and person with mental illness and caregiver of person with mental illness. These are the 5 people will be there in the mental health review board.
As and when you are going through the act, if you have any questions, please write back to us. You have our email IDs, or we have created WhatsApp group and Telegram group. Please bring in if you have any doubts in those groups. We'll try and answer them. If we don't have any more questions, then we would like to bring this session to an end. So we thank Dr. Guru for his presentation, and we thank the audience for actively participating in this discussion. We also like to thank Linux Laboratories for their support through their educational grant.